Thank you. You may be seated. Good morning. We're here today for oral argument in the case of State versus Ballard. Our case number is CR24-0287. These proceedings are being audio and video recorded. We would ask that you state your name and who you represent when you begin your argument. It helps for those who are listening to the audio. Each side will have 20 minutes. The plaintiff will be responsible for reserving any time that you wish for rebuttal argument. We've read your briefs. We've discussed this matter at conference. If you could keep that in mind as you begin your argument. And with that, counsel, you may proceed.
Thank you, Your Honor. My name is Jim Santos. I'm from Jennings, Howe, Keller, McLeod, Waterfall. I'm here on behalf of the defendant, Harold Wayne Ballard. A little off brief, because you've read the briefs. I don't want to repeat everything that you said, but earlier this month, there was an article in the Guardian publication describing what newspapers are now adopting. They call them the clean slate or the right to be forgotten programs, allowing people like Mr. Ballard, who might have been the subject of a news report, to request that his name be removed from the publicly easily available database on the websites, so they don't have to continue to live with a conviction that might have occurred 20 years ago that continues to impact their ability to seek employment or otherwise enjoy their life. Of course, Arizona has a comprehensive system in place to do just that as well. The statutes at ARS section 13-900 in that range all have the remedial purpose of allowing someone who served their time, who paid the restitution, who satisfied all probation, to start to put their life back in place so they don't have to continuously, forever, be punished for the crime that they've committed. And the punishment is the inability to do things that other people do in their life, including seeking employment. And mind you, I think the state's main purpose behind this, although it's altruistic, is to increase the tax base. People who can maximize their employment opportunities without having been turned down time and time again because they have a prior conviction, that increases their tax base, that makes them more successful. It probably also reduces recidivism. So it has all this great purpose behind it, and this entire statute scheme is in place in the 13-900 range.
Would you agree there is some level of discretion, depending on maybe the nature of the offense, that some offenses might lend themselves more to that policy?
There's very limited discretion under ARS section 13-905. I mean, you compare that to ARS section 13-910, where the legislature lists several offenses that disqualify you under that for being allowed to have your firearms. And then the second section of that statute says just if you're not part of the people that are disqualified, it's subject to judicial discretion as to whether or not you receive this benefit. Now, that's not what we have in 13-905. It's discretionary to apply. It says any person who's qualified may apply. But when you're looking at for the discretion of the court, it seems to be very limited. There is the use of the word may once when it describes what the court can do. There's a lot of times where the legislature said the court shall do certain things. In Section A is where they use the word may. The court may issue an order that includes a certificate of second chance to a person whose judgment of guilt is set aside pursuant to subsections K or N of this section. I'm not sure that means the discretion is absolute to the judge, that the court may or may not enter any order. I believe that's the discretion to enter an order that is also subject to subsections K or N, the second chance certificate.
The statute lists factors to consider.
It does. Now, some of those factors have a layer of discretion in them, obviously. I mean, the nature and circumstance of the offense that the conviction is based upon. Well, that's not discretionary. You just go back in the statutes and find out which ones don't qualify for this relief. They're spelled out by the legislature. First-degree murder doesn't qualify. It's spelled out by the legislature.
But the circumstances, sorry.
Go ahead.
The circumstances seem different than just what's spelled out. There can be circumstances that make one person who's convicted of the same crime as someone else, the circumstances may be such that they're not as maybe sympathetic as the next person. Would you agree with that assessment, that circumstances may be more than simply the charged offense?
Do any of them sympathetic or not? Well, I hope not, because not everybody's sympathetic, but they're still equally deserving.
I'm just saying not every crime would be viewed exactly the same, depending on circumstances. Someone may get a nice plea deal based on the same set of circumstances that someone else was convicted of a much greater offense. Would we not consider the overall circumstances of, even though someone may have received a favorable plea agreement?
Well, no. I mean, we're only considering the offense upon which the conviction is based. The statute is very clear on that.
That's the offense, not the circumstances.
The circumstances, sometimes that could be a conviction upon the conviction is based. The circumstances could make it a serious crime. And we have that defined in ARS section 13-706. Those would be circumstances that could disqualify you, perhaps, if it's a serious crime or justifying increases in statutes. So yes, maybe there's some discretion in that, but I don't think it's absolute discretion, meaning that no matter what, the judge has absolute discretion to say no, just because the judge feels like it. Because why else would they set a bunch of very limiting factors to consider if what the legislature meant or anything else you feel about? And again, this is a remedial statute. Its purpose is to give people second chances. That's why the legislature passed the entire sections of the 13900 range.
But I read, for example, 13907 as being more automatic, if you will, compared to 13905. And before we get there, could we ask about your notice of appeal raised 13907 and not 905, but then the brief seems to be addressing 905 and not 907. What do we do with that?
Well,
is that accurate?
To the extent that the brief speaks a little bit broader than the notice of appeal, I don't believe that was intended, and I don't think that it constitutes a waiver of any argument since they've been fully briefed by both parties, and we've been focusing on 905. 907, the automatic granting of your civil rights, that's a little bit different than the relief under 905, but they do.
That's what the notice of appeal was, the denial under 13907. But you're saying we can also consider the 13905 argument?
It's all part of the same order. Yes, Your Honor.
Do you have any authority for that?
Yes, it's cited in the reply brief, Your Honor. If you will read, I talk about how when both parties have fully briefed an issue, what the thought is somebody could waive something, but if it's not waived, then it's briefed, and if nobody is claiming a waiver, then there's really no need for you to claim that there should have been a waiver.
And do we get to 13907? I didn't really see much of an argument on 13907 in the briefing.
I didn't see 13907 mentioned in either.
It's not, and 13907 is automatic, of course.
But how do we say there's some sort of error when neither party has really given us any argument to look at?
Well, the judge has determined by checking the box that all statutory requirements have been satisfied, that's not an issue in appeal.
Right, but how is it an issue before us if you don't ask us for any type of relief under 13907?
Well, again, I don't think it's an issue in the court's order. The court has checked the box that says all statutory requirements have been met.
But we usually like to hear from the other side to explain why that ruling should be set aside or should not be set aside.
Well,
if it's not raised in an opening brief or even in a reply brief, how do we get to the merits of that?
I don't want you to. I want you to assume that all statutory requirements have been satisfied because nobody has challenged the trial court's decision on that issue.
But you want us to grant relief on something where you didn't raise an argument?
The relief, we're challenging the court's decision not to comply or to go beyond the factors required under ARS Section 13905 when the judge said, the reason, although you've satisfied every statutory requirement, I can withhold the order that you requested based upon my determination that other crimes that you were charged with but found, or which charges were dismissed, or as the state has even argued, other uncharged crimes, just make you unqualified for the relief under the statute.
So we're solely operating under 13905 here. And I know 13905 does discuss restoration, firearm rights. But that's where we are. But that's only if the conviction is set aside.
Well, again, the judge has never found that there's any other statutory violation to any of the applications that were submitted before him. So
our question is just, if you didn't raise any argument under 13907, you want us to rule and say 13907 applies here, and his civil rights and his gun rights should be restored automatically, even though we didn't ask for that relief. We asked for relief under 905, and part of the relief under 905, if you're successful, is you have your rights restored.
I don't know other than to say that we didn't challenge the judge's finding that 13907 has been satisfied.
But it's petition to restore civil rights.
Yes, by using 13905 elements.
Counsel, let me ask you, is your 907 thought contingent on whether you succeed or not on your 905 argument? In other words, if you prevail on 905, 907 would follow. If you don't prevail under 905 on appeal, 907 would not be at issue.
Well,
I just want to understand what you believe is properly in front of the court.
yes, Your Honor. Because I believe the trial judge considered factors outside of 13905, a weapon was involved, for example. At the bottom of his order, he would check the box that says the right to possess firearms is denied because the offense is serious under 13706. And of course, the crime that was for which guilt was admitted is not a serious offense. So we're conflating by taking either uncharged crimes or crimes that have been or charges that have been dismissed, adding them to the consideration of the entire application, and then making erroneous decisions on that basis. So my request is for the court to tell our trial judge not to consider uncharged crimes, charges that have been dismissed. On remand, I believe then everything else will fall in place, since the initial finding that all statutory requirements have been satisfied will have been dealt with. Nobody's challenged that. The only challenge was the judge correct to insert other requirements in his consideration, and then magnify that by using a crime or charge that had been dismissed to create a serious offense where no offense like that has been part of the conviction.
Can you address the jurisdiction issue that the state raises?
Yes. There are many, I think 3 different versions of these same orders in the trial court's record. They were issued in various years. They're all virtually identical. They use the same form. They check the same boxes. If one's appealable, everyone's appealable. Now, I know the state said yes, but there was once a case, State v. Botis Flores, where the court said, you know what, I'm going to treat a letter by the way, they had an order like this, which the court said was appealable, but they didn't appeal within 20 days. So the court said, well, we'll look at a letter that we received. We're going to treat that as a motion for reconsideration, the trial court did, and denied it. But it didn't issue an order like this, So when we have an order like this that's appealable, the first time, perhaps, that was when it was denied because it was too soon after his release from probation. And the second order that was issued like this, that was also appealable, the state agrees. And then the third order that looks just like this. I mean, I don't think you can have one order that's appealable and not all three. And we don't look at anything other than the order itself in order to determine whether it's an appealable order. And the focus is on the order. All three have denied application for restoration. So there is no difference in the orders. They are all appealable, no matter how the court might have gotten to issuing that order. It's the order itself that's appealable, not the method by which it got there. And yes, in this case, it did get there, this third order on a motion for reconsideration. But unlike the State v. Botus Flores Court, who treated a letter as a motion for reconsideration, this court treated it as an application and issued an order denying the application. And it makes sense because, I mean, we could apply it next year too and get another set of orders. This is not a, one-time shopping type of a procedure.
And actually, can you speak to that a little bit? So the court issued its denial orders on December 5th, 2023. And then you filed your motion for reconsideration, I believe it was February 5th or somewhere around there. So when the court issued its denials in early December, how soon could your client apply again? Is there any sort of waiting period, or could he have applied the next day? Can you speak to that a little bit?
I did not find any statutory waiting period in between applications. There are some statutes that talk about how soon you can apply for certain restoration rights in the 13900 section of the statutes. Like if you have a certain crime, you shouldn't seek restoration of certain rights for 5 years or for 10 years. But no, there's not anything like that here. And then just like in State v. Botus Flores, that was two orders that the court found appealable, and the letter, or the minute entry denying the letter, the court found not appealable. And of course, I also, in our reply brief, talked about how where it's a pure issue of statutory construction, an issue that the state agrees has never been dealt with before, that the court could accept, and I asked that the court would, if it need to, accept special action jurisdiction and to reach the statutory issue as to whether or not a trial court should be factoring in dismissed charges that an accused is presumed innocent of when determining to deny relief under the statutes that are subject to the applications.
Our ability to treat a putative appeal as a special action, sua sponte, though, presumes that the appeal is timely, correct? If it's not timely, we have no jurisdiction to do anything as an appeal or a special action.
I don't know that there is a time limit for filing a special action per se. And if this came in to the court as simply a special action, I think the court would have had the discretion to accept it or deny it like it always does.
The point I'm making, though, is if we lack jurisdiction to convert an untimely appeal into a special action, there's case law from the Supreme Court and this court saying.
I'm not going to argue with that. I'm not aware of that, Judge. I'm sorry. But if that's the case.
I just want to make sure I understood your argument correctly.
Okay. If it's all right, I may reserve the rest of my time. Thank you.
Your Honors, good morning. May it please the Court. My name is Quentin Gregory. I'm here on behalf of the Maricopa County Attorney's Office today, representing the state of Arizona. I'd like to start with the Court's questions about jurisdiction. And
Could I go in a little bit different direction first?
Of course.
I'd like your view on 13907.
Sure.
Whether it's mandatory that civil rights and gun rights be restored, and is it mandatory under the statute if the conditions are satisfied, and what's the state's position on whether they've been satisfied or not?
So my reading of the statute is that it is mandatory. I believe that it's also retroactive. However, in the case where a conviction is as old as this one, the courts probably, just practically speaking, aren't going to be able to enter those restorative orders, and so it might be incumbent on the defendant to bring that to the court's attention.
In this case, the defendant brought it to the court's attention. The court has denied that motion. Do you agree that he's entitled to relief under 13907 to have his civil rights and gun rights restored?
So because of the way that the briefing was done in this case in front of this court, and that's what we responded to, I can't commit 100% to an answer, but I would agree if the conditions of the statute are satisfied, and given the nature of 907's relief that it provides that it's automatic, then the court wouldn't have discretion to deny such a motion. And so that could be an error that might be rectified. Whether it's in front of this court, I don't think it is, because it hasn't been briefed, and we certainly haven't had the opportunity to respond to it.
But you had an opportunity below, and
the state did not respond below.
No response. So why? And I guess it was raised below. I get that it wasn't raised in the opening brief here, but so you're just saying you're not willing to take a position that yes, his civil rights and his gun rights should be restored.
That's correct, Your Honor, and only for the simple fact that because we didn't respond below, we've never taken a position on the merits of whether he's entitled to set aside or restoration of rights.
Can you think of any reason why he would not be entitled to that?
I can't think of any reason, Your Honor, no. I'm just not familiar enough with the underlying record in that regard, because that's not the direction that the case took. And so that, frankly, wasn't relevant to the 905 issue and the jurisdiction issue that the state responded with. I will say, though, as a practical matter, if 907 does apply, the defendant can walk out of the courtroom today and file that petition again, and to the extent that he is able to show that he's entitled under those factors, and only those factors, this court can issue a separate ruling about the 905 issue and the jurisdiction issue, but under 907, he's free to file that standalone petition again. We've never disputed that there's a limit to the number of petitions that can be filed under these statutes. And on that note, I wanted to respond to a question raised about the time limits that apply. And the state concedes that there are no time limits under 905. There is, however, subsection, Rule 29.6 discusses it, and it only allows the filing of a new petition, quote, after satisfying all requirements or after resolving any other reason for denial. And so even in the circumstance, which the state disagrees with, that the motion for reconsideration is treated as a new petition and then the court's subsequent order is a separately appealable order, I think that Rule 29.6 would clearly support the court's denial, and because this court, under abuse of discretion review, will affirm for any reason, the violation of 29.6 would support the trial court's denial, because it doesn't really stand to reason that 2 months after the December 2023 denial, there had been a circumstance that had changed and the court's concerns had been addressed when the court denied the petition due to the nature of the offense and the utilization or the possession.
Did the Superior Court essentially treat it as a new petition and address it on the merits?
I think that elevates form over function. In terms of briefing and statutory interpretation, it's fundamental that we don't just look to the title of something, we look to the substance of it. And so when the February 2024 motion for reconsideration was filed, setting aside what the document was titled, you look at the first paragraph, and it's only a page and a half. The first paragraph, the last paragraph are essentially copy-pasted versions asking the court to reconsider its December 2023 denial. The only argument that was made in there was essentially the substantive argument that's been raised here, that 905 subsection 1, or C, sorry, subsection 1 and 7 don't permit the court to look beyond the facts, basically the factual basis supporting the plea, and that's incorrect, we think, for other reasons discussed in the brief. But when the court received that motion for reconsideration, it wasn't provided with the necessary information to make a new determination, because again, going back to the rules, 29.2A provides a litany of requirements for a petition to set aside.
Counsel, let me ask you, though, two things with that. The Superior Court could have treated the February 2024 motion differently than it did, but it looks kind of like addressing the merits of it, doesn't it, and actually made some additional, include some additional text above and beyond the prior ruling. Wouldn't you agree?
There's slightly additional text. I think it expanded a little bit, the brief 2 or 3 sentences in its reason for denial.
It's terse, for
but
sure.
It did start with, as stated before.
But let me ask you, the other question I have is to your 29.6 argument, and you were getting to the point of saying 2 months wasn't long enough. Well, given what the trial court found, would 20 years have been long enough to refile? I mean, it was sort of the nature of the offense, and I get your point on timing for 29.6, but it's not at all clear to me that the basis for the original denial, that time would ever have fixed that. And I hope you're not saying that 29.6 would preclude any sort of subsequent petition.
No, of course not.
So if 2 months was too short, when would have been enough time, do you think?
I think, I can't speculate as to enough time. I mean, it's certainly been, 20 years now.
Right.
Sure, but given the reasons for the court's denial, I think I agree that it does seem so broad, and it's just focused on what the defendant did. There's no concrete, here are things that you need to address, and so it is a little intangible as to what can be done, and I think time is really the only thing, and I don't know what the limit is.
Well, but
and
I hear you saying time's the only limit thing, the only limit, that 2 months is too short, and I guess because it's your argument, I'd be delighted to know what amount of time wouldn't
Sure.
be too short.
I think that that's just to the discretion of the trial court. I don't have an exact number of days, but what I do have is, it's in the Tiao case, State versus Tiao, cited by both parties, I think it's fundamental to recognize that a convicted person doesn't have a fundamental right to have a conviction set aside.
And so, but if it's left to the perhaps almost unfettered discretion of the trial court, why is 2 months too short?
I think that argument, if I can try to maybe reframe it a little bit, is more made for the benefit of this court's review, that 2 months after one petition is denied because of the nature of the offense and the utilization of a gun, filing the same request 2 months later would potentially be violative of Rule 29.2, I think it was.
And I misspoke.
And so,
I thought I'd written down 29.6.
2 is the other one, I apologize. You're correct, Your Honor. 29.6. And so, because, again, this court affirms for any reason, supported by the record, the court, I think, could interpret saying, okay, given the reasons for denial, the passage of only 2 months before the filing of a new motion, it is understandable. There is a reasonable judge out there who would think that this is not, that in this period of time, the defendant hasn't been able to address these concerns. And go ahead, I'm sorry.
Your office didn't oppose that, and even though the court didn't say, oh, under 29.6, I'm leaving this alone, this is too soon. We could do that, is what you're saying, even though those...
That's correct, yeah. And I cannot emphasize enough that we did not oppose this below, and on the merits of whether he's entitled to this, under the statutory factors, the state continues to take no position. But I do want to get back to the jurisdiction argument, and I agree, as Judge Thumma pointed out earlier in the reply brief, the defendant said that this court could save his petition or his appeal if it is untimely with special action jurisdiction. And as you recognize, Judge Thumma, something can only be converted to a special action and saved in that manner if it's not done so for reasons of untimeliness. That's in, I think, new rule 11E, and then even under the old rules, the Supreme Court, our state Supreme Court in Neely v. Rodriguez recognized that timeliness will always be a bar to an appeal, and it can't be saved by special action jurisdiction.
Counsel, do you think that in the notice of appeal, as we previously were discussing with your opposing counsel, they only listed really 13907, restoration of civil rights and firearm rights, in the notice of appeal. Is that fatal to this appeal?
Frankly, I'm not sure of authority on that point and what Rule 31 says about that. I do think,
Didn't raise it.
and we didn't raise it, yeah, so sure. So the state,
Been briefed.
just as the defense may have waived a 907 argument by not briefing it, I think the state would waive any argument against 907 by not briefing it, but that argument also was not presented there. So it seems the cleanest way it would be to find waiver and address only what's been briefed and argued to this court. And so that, I'm not sure the direct answer to your question, but I think in favor of equity, that would make the most sense for both parties.
Okay, but in terms of the appeal, kind of what's been briefed and what we're looking at today, it's your position that we're solely under 13905.
I agree with that, Your Honor, yes.
Could you help me just understand it? There may be very good reasons for the state not taking positions when it's filed, but it's a little bit odd that there's no objection. I mean, it's not an affirmative, yeah, we support the petition, but the state doesn't object when someone files it. It's odd in the context of one that's automatic. It seems like it should be a waiver under 13907 if the state doesn't come in and object. But does the state ever take a position on petitions under 13905?
I believe, I'm not sure exactly, I believe that if such a petition is filed very early after a conviction or a sentence is completed, then depending on the nature of the crime, the state may step in, and because there are duties to notify the victim, if the victims approach the state and request that such a motion be opposed, then the state might step in, but obviously that is not what was done in this case. This was a victimless crime. It's, at least in the context of the recent petition, it's a very old offense, and so the state did not take a position.
But the state does take a position if the court rules and says, no, I'm not going to grant that. The state does come in and at least say there's a basis for what the Superior Court did. Is that the reason for coming in at this point?
The way that the state's looking at this appeal is that our position right now is to defend what we think is a justifiable order by the trial court, and to not protect, that's the wrong word, and to essentially attempt to enforce what we view as a jurisdictional issue under 4033. And so those are the only two positions that we're taking in this appeal.
And if they go in and file one in 4 months and it's denied and they file an appeal 10 days later,
that would be timely.
That would be timely, but would you come in and object if the court denies that petition? Does the state come in and say, no, we're supporting independent of time limits? Is that the only reason you come in, or you view it as a discretionary call that should be upheld?
A discretionary call of the trial court.
Right.
I'm trying to imagine, I mean, if it were clear to the state, because of course we would be notified, get the notice of appeal, review the case, and every case has a separate set of facts and circumstances, there could be a case where it becomes clear to us that the judge committed a legal error that we wouldn't be able to defend. But here, where it seems like it was a purely discretionary exercise by the judge, and what Judge Green did is supported by the record, and we think the law and the Constitution in terms of the argument of what subsection 1 allows when you're looking at the nature and circumstances of the offense, then the state is, if not obligated to, at least able to step in and defend that order in front of this court. Because obviously the Superior Court does not send representatives here to defend those orders. And I wanted to, going back to the jurisdictional issue, I think that we've talked about in the briefing the Perry case, where the petition to set aside, restore gun rights was denied, and then the defendant filed a letter that was treated as a motion to reconsider. And the court denied that, and then a notice of appeal taken from that was untimely. I really think that that case is where this case can and should stop. Because even though the form and the appearance of the judge's order denying the motion to reconsider looks like it's addressing a new petition, it simply was not. It was addressing, the trial court only has the authority to address a motion that is before it. And there was not a new petition that was filed. There was a motion for reconsideration that asked the court to reconsider a previous order, and it provided brief legal argument, and the court denied that, stated same reasons as before, and only from that motion, about 5 months after the initial denial in December 2023, was a notice filed with this court. And I think this also mirrors, and this is unpublished authority, but it's a case called State versus Stock from last year, and that may sound familiar. Judge Payton was on that panel, and that was in the context of a Prop 207 expungement, which I think is analogous to this, because like set-aside petitions, a Prop 207 expungement request could ostensibly be requested as many times as you want. You get denied, you file another request. You get denied, you file another request. And there, the petitioner filed his petition, was denied, filed a reconsideration motion, was denied, and then filed a new petition. And he appealed from that second denial of the new petition. And in granting jurisdiction to hear that appeal, this court said, we are granting jurisdiction over the second denial of the petition, and we admit that the state is correct that had this been taken after the motion for reconsideration denial, it would have been 100 days late. And here, I think it's the same exact case.
Is that just a summary denial of a motion to reconsider without any further development?
In terms of how the court issued its order?
Yes, in the case that you're referencing.
I don't, the case does not state exactly what the form of the court's order was, but I would assume that it was something in the form of a minute entry. I don't believe the court, in my experience dealing with Prop 207 issues, the courts don't have a form like they do here in the set-aside context. They dispose of those cases by minute entries. And so it would look different, but substantively it is the same, and I think it should be treated the same. And the time limits of jurisdiction are black and white. It's a calendar issue. You look 20 days ahead, and that's it.
In that case, though, and again, it is murky here because the orders look like each other. I mean, they're kind of robust. They're not denied summarily. But in Stock, do you recall, was the denial of the motion reconsidered by the time the appeal of the second ruling came up? Mm-hmm. It strikes me that more than 20 or 30 days would have passed since that issued. So regardless of how you treated that, it would have been untimely.
An appeal taken from the motion to reconsider denial.
Your avowal, I think, was that the court indicated, and we can find the memo decision, of course, but that the appeal was taken about 80 days after the denial of motion to reconsider, which absolutely would have been untimely.
That would have been untimely, and that's what the court said in that decision, is that if this appeal had been taken from the motion to reconsider denial, it would have been, I think it said, more than 100 days late.
And I get that. The confounder or the difference here is we have motion to reconsider that at least arguably seems to have been treated as a new petition. Now, I understand your point is, look, it wasn't, but it's a tweener.
Yeah, and if I see my time is expiring, if I can respond to that.
Sure, and I do have one more question.
Okay. I understand the court's reticence, but I just don't believe that the form that when we're looking at jurisdiction, we should look at the picture of what the issued order looks like. The substance of the order is denying the same relief that had already been requested a couple of months before that. And just as we look to the substance of a motion, I think that looking to the substance of an order is, I think if we asked Judge Green what she was thinking, she would have said I was denying their motion to reconsider and just use the set-aside form. Obviously, I can't avow to that. I don't have a signed document swearing to that, but so that.
Sorry to keep you over, but I do have a question. Assuming we were to get to the merits, and if the argument was made that a gun was not used in this offense, if we were to conclude that the court got it wrong, that a gun was not used in the offense, what would be the remedy? Well, first, do you agree with that assessment that a gun was not used in the offense?
I disagree with that. I only agree that a gun was not a necessary predicate to the factual basis that was made in the plea agreement. Now, every day, plea agreements in this state are made to crimes that are much less onerous and have much lighter sentences than what's...
How was a gun used in the offense?
A gun was possessed in the offense, and I know that their contention has been that the defendant was in the driver's seat and the guns were not within reach of him. The record does reflect, and I do take issue with defense counsel had stated in the brief that there's not even reliable hearsay in this record that guns were present in the offense, and that's simply not true. There are police reports that are attached to the complaint, and then those were probably utilized in drafting the PSR for the sentencing judge. And so there is that reliable hearsay evidence in the record indicating that guns were, I think the word that the court used is utilized in the offense. But under the factual allegations, that it is seemingly more accurate to say that guns were possessed or at least constructively possessed in commission of the offense. Thank you, Your Honor.
If you could have 1 minute of rebuttal.
Thank you, Your Honor. Let me speed through some things. First of all, I was talking about I was talking about State v. Perry when I was talking about the letter, and I kept using the other case just because when I looked down, that's what I saw. That's one of the waiver cases. On the jurisdictional issue, Rule 31.2 says the notice of appeal must be filed no later than 20 days after the entry of the judgment or order. So what do we look at? We look at the order. We don't look at how an order can come out a lot of different ways, but this one came out and it's clearly just like every other appealable order. And the case cited at page 9 of our reply brief, Nielsen v. Patterson, talks about basically, listen, the rules aren't designed to trick people or to prevent them from having their day in court. And I cited the more exact quote there, but in just that's what it says. And it says basically that if this close call, then the court does have jurisdiction. This is an order under Rule 31.2, and an appeal was taken timely. I agree that there's no fundamental right to have your crimes discharged, your convictions discharged, but there is a statutory right. And under the statutes, that's all I'm asking, is that the statute should be followed. And I can't tell you how many times I heard the nature and circumstance of the offense today. Judge, you used that term. Without the last several words that the conviction is based on. So that's the critical part. Were there any guns involved in the nature and circumstance of the offense that the conviction is based on? If you believe Mr. Ballard is guilty of the offense that he was convicted of, conspiracy to possess or for sale some drugs, then you also have to believe that he's innocent of all the crimes that were dismissed. It can't be a one-way street. I mean, when the parties sign these agreements, it's both. Mr. Ballard's guilty of what he accepted. He's innocent of all of the charges. There was no gun involved in any charge upon which the conviction was based. Those have all been dismissed. and I'm out of time. Or maybe I already was out of time.
We'll give you another 20 seconds if you have something to wrap up.
I don't.
All right.
Thank you, Your Honors.
Thank you. With that, we appreciate both of your arguments. We'll take this matter under due course and take this matter under advisement and issue a decision in due course. Thank you.